Hello, I'm Ralph Wilde. On the 30th of December 2022, the United Nations General Assembly voted to request that the International Court of Justice in The Hague render an advisory opinion, essentially on whether or not the Israeli occupation of the Palestinian West Bank, including East Jerusalem and Gaza, is illegal, and if so, what the consequences of this are for Palestine and the Palestinian people, for Israel, for other states and international organizations, including the United Nations. This legal opinion is from the United Nations Court, which hears disputes between states and also provides such opinions to the UN. It's entirely separate from the nearby International Criminal Court, which applies international criminal law to individuals. However, the ICJ will be applying all areas of international law to answer the question put to it. Although it cannot determine individual criminal responsibility, it will have to determine violations of international law that such individual criminal responsibility would be based on, since individual criminal responsibility is essentially a subset of the areas of international law that states are responsible for. The ICJ will also address those other violations of international law that don't give rise to individual criminal responsibility. So what then will the ICJ have to address? I'll summarize what I've set out in a legal opinion you can find online, which I published the day of the General Assembly vote requesting the opinion of the ICJ. I should make it clear that what I am saying here is based on that only. Since publishing my legal opinion, I was asked to serve as senior counsel and advocate to the League of Arab States in this case. I must stress that my remarks today are based exclusively on that earlier legal opinion published before I was taken on by the League of Arab States, and nothing in what I am saying here now should be taken as any indication of the view of the League of Arab States, either generally or in the context of the advisory proceedings and the advisory opinion proceedings before the ICJ in particular. Now, legality or illegality can refer to the existence of the occupation or its conduct or both. As to existential legality or illegality, the occupation, simply by virtue of exercising control over the West Bank, including East Jerusalem and Gaza, consequently preventing the Palestinian people from full and effective self-governance, constitutes a fundamental impediment to the realization of the right of self-determination enjoyed by the Palestinian people in international law. The only basis such an impediment could legally be justified is according to the law on the use of force, the jus ad bellum. Assuming hypothetically that Israel had a right of self-defense in 1967 that justified legally the introduction of the occupation then, and that is an assumption, this justification has not persisted, if it did persist and exist at the time, nor has an alternative legal justification arisen. There has been no actual or imminent armed attack justifying as necessary and proportionate the occupation as a means of self-defense. And the doctrine of anticipatory or preventative self-defense, justifying the occupation as a means of stopping a threat from emerging, has no basis in international law. Neither United Nations Security Council Resolution 242 nor the so-called Oslo Accords provide an alternative legal basis for the existence or the continuation of the occupation. Indeed, the Oslo Accords are themselves violative of international law because consent to them by the PLO was coerced through the illegal use of force, and relatedly, they conflict with norms of international law that have a special non-derogable or Joscogan status, which are the norms prohibiting the use of force other than in self-defense and the right of self-determination. More generally, there is no international law right to maintain the occupation pending a peace agreement, and or as a means of creating facts on the ground that might give Israel advantages in relation to such an agreement, and or as a means of coercing the Palestinian people into agreeing a settlement to the situation that they wouldn't accept otherwise. The consequence of what I've said is that there is no valid international law basis for the existence of the occupation. In consequence, the occupation is an unlawful use of force, an aggression, and a violation of the right of self-determination of the Palestinian people on the part of Israel, and, in the case of aggression, also potentially a crime on an individual level for senior Israeli leaders. As a result, the occupation is existentially illegal and must end immediately. Legally, the requirement of termination is not contingent on particular circumstances being present. Specifically, the following factors or conditions cannot be by themselves a pretext for delaying termination: willingness or consent by Israel, the adoption of a peace agreement, the adoption of standards within or the giving of undertakings by the Palestinian people, approval by the United Nations, the Quartet, or other states. So in consequence, every day that the occupation continues is a breach of international law. The existential illegality of the occupation arises out of the simple fact of the occupation as a system of control and domination, without a valid legal basis. This is then compounded by the occupation's prolonged duration, its link to de jure and de facto annexation, and the egregious abuses perpetrated against the Palestinian people. The use of military force to annex territory is also an independent basis for existential illegality, also a violation of the international law of the use of force, and also an aggression at both the state level and potentially in terms of individual criminal responsibility. By contrast, the prolonged length of the occupation and its abusive nature are not independent bases for existential illegality, but are relevant as aggravating factors to the question of existential legality as a matter of the law on the use of force. The abusive nature is also relevant to the separate matter of legality or illegality of conduct. Any purported annexations are also without legal effect, because in international law, Israel is not and cannot be sovereign over any part of the West Bank or Gaza, including East Jerusalem, through the assertion of a claim to this based on the exercise of effective control enabled through the use of force, and in the absence of consent to such annexation freely given by the Palestinian people. As to the legality or illegality of the conduct of the occupation, there are multiple egregious breaches of the relevant areas of applicable international law, and those are the laws of war, or the law of armed conflict, or the jus in bello, or international humanitarian law, including occupation law, international human rights law, and within this, the prohibition of racial discrimination generally and apartheid in particular. These are breaches at the level of the state of Israel and also, in some cases, depending on further findings on individual criminal responsibility, individual crimes, war crimes, crimes against humanity, the crime of apartheid, and the crime of torture. So to conclude then, the occupation is illegal in both its existence and its conduct. And in both cases, this gives rise to both state and potentially individual criminal responsibility. Thank you.